Okay, we are streaming live now and Jeff is on. Good afternoon to all of you. Thank you for your patience as we gather ourselves to be here for this bench trial. Calling case U 5630752, City of Detroit versus Mario Petway, count one, brandishing a firearm in public. Appearances for the record.
Good afternoon, Your Honor. Tamika Horn on behalf of the people, P70303.
Thank you.
Good afternoon, Your Honor. Ryan Hill, P68445 on behalf of Mr. Mario Petway. Mr. Mario Petway, state your name again for the record, please.
Mario Petway.
Sergeant Jackson, if you could please put your name and badge number on the record as well.
Sergeant Michael Jackson, badge S413.
Right. Counsel, before we begin, are there any preliminary matters that we need to address before starting this trial today?
At this time, Your Honor, we've discussed the amendment of the ticket in which counsel did not have any objections to. The ticket should reflect the year of 2020. And lastly, Your Honor, the ordinance in which the people are proceeding under is section 31-13-24 of the Detroit City Code.
Okay, hold on. 31-13-24 of the Detroit City Code.
That is correct, Your Honor.
Okay. And the amendment of the year from 2000 to 2020. Okay. Defense counsel, do we have any objection to the amendment, to either of those amendments by Madam Prosecutor?
I don't have any objections. If that's what you meant, Judge, sorry.
That's okay. All right. Okay, any other issues that we need to address prior to starting this trial today?
No, Your Honor, not that I am aware of at this time.
Okay, anything from Attorney Hill?
No.
Okay, all right. At this time, if I could please have Mr. Petway, please raise your right hand. Do you swear or affirm the testimony you'll give to this court today will be the truth, the whole truth, and nothing but the truth, so help you?
Yes.
Okay. Counsel, well, Mr. Petway, you can lower your right hand at this time, Mr. Petway. Mr. Petway, do you understand you have a constitutional right to a jury trial?
Yes.
All right. And you also have had an opportunity to consult with Attorney Ryan Hill regarding this case today, is that correct?
Yes, ma'am.
And are you voluntarily giving up your right to a jury trial and you choose to be tried by this court today, sir?
Yes. Can you explain that to me? I'm sorry.
I can, Judge. I can explain. Mr. Petway, remember we talked in the breakout room and I said that you have an option of having the judge hear the case, or if you want to adjourn it and send it out. They're not doing jury trials right now, but it would be probably in months down the road, you could have people in the community sit and hear your case and make a determination on whether or not you're innocent or guilty.
Okay.
Right? And I believe we discussed this as it relates to, you're okay going forward today with the judge having her hear your case?
Yes, sir.
Okay, and you understand that that means you're giving up your right to a jury trial, sir. Do you understand that?
Yes.
Okay. Has anyone promised you anything to get you to waive your right to a jury trial?
No.
Okay. Has anyone threatened you to get you to waive a jury trial today?
No.
And is it your free choice to waive a jury trial in this case?
Yes.
Counsel, I understand we do not have a written waiver form based on us handling this matter by Zoom. However, do I have is your client, I believe I have a written waiver, but I need to know that you guys, that you are in compliance with that, and do I have the consent of the prosecutor on the obtaining that consent, that waiver of the jury trial?
Yes, Your Honor.
Counsel?
I think you've complied with the court rules, especially during the pandemic. My client has obviously given an oral declaration for a waiver. I think we're good.
Okay. And Mr. Petway, are you waiving your physical presence to have this case heard in person, and are you agreeing to have this case heard by Zoom today?
Yes.
Okay, counsel, your client has been arraigned in this case, is that correct?
Yes, Judge.
Okay.
Yes.
All right. All right, we can proceed with trial now. Will there be opening statements in this case?
No, Your Honor, the people waive.
Okay,
We're
All right.
waiving too, Judge.
okay, understood. All right, at this time, would you like to begin?
Yes, Your Honor. The people would like to call its witness,
Okay.
Sergeant Michael Jackson.
All right, Mr. Jackson, Sergeant Jackson, can you please raise your right hand for the court, sir? Do you swear or
Yes,
affirm the
ma'am.
testimony? Thank you. Do you swear or affirm the testimony you'll give to this court today will be the truth, the whole truth, and nothing but the truth, so help you?
Yes, ma'am.
All right, and before we begin, the applicable statutes in this case are Detroit City Code Municipal Section 31-13-24, and the underlying MCL statute for that code is MCL 750.234, subsection E, for brandishing firearm in public, applicability violation is a misdemeanor penalty. Okay, you may proceed.
Thank you, Your Honor. Sergeant Jackson, where are you currently employed?
City of Detroit Police Department, 20 Atwater Downtown Services.
And what is your current position?
Master Sergeant.
And please describe how long you've been a police officer.
35 years.
And what kind of training have you received over the 35 years?
Extensive. Narcotics, gang, tactical. Been around a little bit.
Understood. And what kind of training have you had or experience have you had in dealing with firearms?
That was pretty much one of my specialties. My career, I've probably made thousands of concealed weapon arrests.
And do you know the difference between a real gun and a fake or facsimile firearm?
Yes,
Okay. And in this case, was it a real or fake firearm?
it was a real gun, real Smith & Wesson semi-automatic 9mm.
What did your training over the 35 years teach you to look for in regards to conducting a firearm investigation?
Judge, I'm going to object to the questions as to relevancy, and I'll stipulate to the officer's experience as it relates to firearms. I know Sergeant Jackson. I think I've had other cases with him before. So I'll stipulate to his experience as it relates to identifying firearms.
Okay, thank you very much, counsel.
You're objecting as to relevancy, correct?
Yes, and I think we can move on because I stipulated to his experience.
And the people's explanation is just to establish that Sergeant Jackson has extensive training and knowledge and experience in working with firearms. So there's no question as to the particular firearm that is the subject of this matter.
Okay, and so the question as it relates to relevancy was related to was specific to his entire testimony as it relates to him just having extensive knowledge about firearms, or was it related to anything specific that the prosecutor was asking? Attorney Hill.
I'm sorry, I'm confused now. I just thought that Madam Prosecutor was, she asked a question about being able to identify a firearm. If I'm just stipulating his experience that he identified a gun, I can say, once you hear testimony from my client, we'll stipulate that it was a real gun. Does that make it easier?
That's fair.
Yes, the court will overrule the objection then as it relates to relevancy, because the court does believe that this evidence is offered for evidence that is material to this case. Okay, you can proceed. Understanding the court does note that Attorney Hill did stipulate to the experience of Sergeant Jackson, but I want to make sure the record is clear. Okay, proceed.
Thank you, Your Honor. Sergeant Jackson, on August 16th, 2020, at approximately 1:25 a.m., were you on duty?
Yes, ma'am, I was.
And where were you on duty? What location?
At the time, I was sitting in the area of Randolph and Broadway. I was monitoring the Well and the Baltimore bars. They're located next door to each other, 1218 and 1234 Randolph. They had a open plaza type bar setting where patrons were standing outside, drinking, congregating, and basically partying. I observed about 50 persons take off running in different directions.
Judge, I'm going to object. This is becoming a narration. There was no question there. I think that there was a question, it was answered. Now it's becoming more of a narration.
All right, sustained. Please change your question.
Is that location within the city of Detroit, Michigan?
Yes.
Okay. Is the person you spoke to that is the defendant in this matter here in this Zoom hearing?
Yes, Mr. Petway is wearing a yellow colored work vest.
And Your Honor, let the record reflect that Sergeant Jackson has identified the defendant.
So the court will acknowledge that Sergeant Jackson has properly identified it.
Judge, can I voir dire Sergeant Jackson as it relates to the identification very briefly?
Yes.
Sergeant Jackson, are you identifying my client as the defendant simply because he's the only one here on Zoom and his name is listed Mariel Petway?
I remember his face. I have pictures. I have his CPL card, so I remember him.
Thank you. That's all I needed, Judge. Thank you.
Okay, thank you.
Thank you. Did anything happen that evening or that morning, technically, that led you to issue Mr. Petway a ticket?
Yes. I was with a female friend.
Whoa. No. Mr. Petway, it's not your turn yet.
Oh, I thought you asked me. I'm so sorry.
That question's for the sergeant, okay? Just hang tight, okay?
I'm so sorry. I apologize to the court.
That's okay, Mr. Petway. Mr. Petway, I'm going to mute you, okay, until I'm ready for you to speak, okay? Thank you.
Yes.
You proceed.
And I'll restart. What led you to issue this ticket?
Well, I saw 50 persons take off running in different directions. I scanned the crowd and a lady flagged me down and said there was a person waving a gun in the crowd.
Okay, and so you proceeded in that direction towards what you were flagged for?
Action leading.
Did you, I'll rephrase.
Let me proceed. Sustain. Rephrase your question.
In
which direction did you go after you were flagged down?
I drove up to the bar, Randolph and Gratiot. Then I observed Mr. Petway with the gun in his hand, kind of like waving it and brandishing toward the crowd. He had two small children with him. And
okay. I'm going to stop you there because I don't want this to be a narrative. So if you could just answer each question just as I put them.
Okay.
Was there anyone else with Mr. Petway?
He had two small children. I don't remember the ages, maybe 5 and under.
And what did you say to Mr. Petway? Did you approach Mr. Petway first?
Yes, I observed Mr. Petway proceed northbound on Gratiot from Randolph. He still had the gun in his hand. And I approached him at gunpoint and ordered him to drop the gun.
And then, Sergeant Jackson, was he on foot or was he driving a vehicle?
He was on foot walking.
And what was the first thing you did when you approached Mr. Petway?
I approached him with my gun in my hand in a low ready position. I ordered him to drop the handgun. He dropped the handgun. I recovered it. I put him in handcuffs. And he put him in my police car. He told me that he had a concealed pistol license.
Okay. And were you in full uniform at that time?
Yes, ma'am.
And had you identified yourself to Mr. Petway?
I was in a fully marked white police car in full Class A blue uniforms, clearly identifiable.
And was this a public area?
Yes,
And was it your belief that did you believe Mr. Petway to be a peace officer?
I did not.
Did he identify himself as a peace officer?
He did not.
Was he defending someone?
Objection, Judge, relevancy, and I don't think there's been a foundation as it relates to any defense.
Okay, hold on. Is there a response?
The people believe this is very relevant because the underlying statute and Detroit City Code accept brandishing a firearm.
I'm okay with that. It's a speculation, right? If Sergeant Jackson had a conversation with my client and he asserted that, I'm okay with it. You asked him whether or not he was defending somebody or someone else.
Understood.
The court will sustain the objection as the court does not see how there's been any foundation set up for the questioning that you're asking, and it relates to the relevancy of Mr. Petway's intention at that time. If you could change your questioning to
Yeah.
Understood. I will rephrase. Did he tell you he was defending himself?
He did not, and I did not see a person there that was an imminent threat to his life.
And did he tell you that he was defending someone else?
He may have made mention that he was involved in some type of altercation, but I didn't see that.
And you've already stated that what I was going to ask you just now. Okay, no further questions right now at this time, Your Honor. Thank you.
May I, Judge?
1 second. Okay, counsel, you may proceed.
Mr. Petway, I'm sending you a chat right now. Can you look at that? Do you see that?
He's muted, sorry.
It's okay. I just want to make sure you can see it. That's all. Okay, good. It's okay. May I, Judge? May I proceed?
Yes, but I need your client to unmute himself so that he can answer a question. Okay, please press unmute again, Mr. Petway. Thank you.
All right, Mr. Petway, did you see my message to you?
Yes.
Okay, all right.
Yeah.
So, Sergeant, I'm just going to have a couple follow-up questions. If you don't understand what I'm asking, just say, hey, Ryan, repeat it, and I'll repeat it, okay?
Yes, sir.
Okay, so you're sitting in a car in Randolph and Broadway. I'm familiar with the area. Would you say that's about 100 yards away from where you interacted with my client? Roughly?
Maybe less.
Maybe less? Okay. So I'm familiar with the well in the Baltimore. You're parked outside?
I was parked on the west side of the street. I was on Broadway and Gratiot, pretty much.
Okay, and you actually interacted with my client outside of Buffalo Wild Wings, correct?
No, I initially detained him on Gratiot, north of Randolph. I had him in my police car, and I ended up bringing him back around to Randolph and Monroe area.
Okay, so you're sitting in your patrol vehicle. Did you have a partner with you at the time?
No,
And this happened in August. Do you recall if you had your windows open or closed prior to the female coming to get you saying, hey, there's somebody with a gun?
my windows were down.
Okay. Do you recall on the date shortly before interacting with my client hearing gunshots?
I never heard any gunshots.
Okay, there were several reports that evening of gunshots, wasn't there?
I don't recall hearing any reports of gunshots.
On August 16, 2020, there was no reports or no one arrested for firing a firearm shortly before this incident?
The people would object. There's no claim that there were shots fired. The issue is brandishing.
I understand that, but I'm asking if he has any recollection as it relates to if there was a report of gunshots being fired prior to my client being arrested.
The court is going to overrule the objection only because he can still testify to his recollection and whether he knows whether something happened. If the court does find that the evidence could be material to the case. Okay.
So, Sergeant, do you recall whether or not there was a report of gunshots being fired that evening?
I do not.
Okay. And did you ever? You said there was 50 people running, and I read your ticket. Did you ever interview any of those people after the arrest?
I did not. Those people scattered. I was looking for an actual victim, but no one came forward.
Okay. So, and the lady that said you somebody was someone had a gun. Did she say anything else besides that?
She said it was a guy waving a gun at the crowd.
Okay.
And at that time, I went to investigate.
Okay. And it's your testimony here under oath that you don't recall shots being fired prior to interacting with my client, correct?
No.
Okay. And you said something about you recall vaguely, potentially, my client asserting some type of defense as it relates to self-defense, correct? So he was trying to help somebody out?
He said that he had an altercation with someone or something vaguely to that.
Didn't he
point.
actually, I'm sorry, didn't he actually tell you more specifically that there was an individual that had a handgun that actually fired shots in the vicinity close to him?
He did not say that, and I was there, and I didn't hear any shots fired. I saw the people running.
Okay.
I was there watching that bar,
Okay. So,
just in case something like that did happen.
okay. And you indicated he has a valid CPL, correct?
Yes.
And upon cursory review of your ticket, he was compliant with your orders as it relates to him dropping the firearm, correct?
Yes.
Didn't give you a hard time, did he?
No.
Okay. All right. So you have no independent or personal knowledge as to whether or not somebody was threatening imminent harm my client, do you? Because you weren't there.
I have no knowledge of that.
Okay. All right. But he did make reference to some type of threat, and that was the reason why he pulled out the gun, correct?
He said he had an altercation with someone. He said someone tried to jump him or something to that effect.
Okay. Something to that effect you don't recall?
Right. I don't recall the actual wording, but something close.
All right. Is there a reason why you left that out of on your ticket? Your ticket's very, very detailed. Is there a reason why you didn't make reference to that on your ticket?
Well, there's no reason. I knew I would have my day in court and I would testify. I'm going to be honest.
Okay. And again, you never went back and asked anybody at the bar, anybody at the bar, these people running, you never followed up with them as to why they were running, did you?
The one lady said that there was a man waving a handgun in the crowd. That's what got me to conduct a further investigation.
Okay. And after you detained my client, you had a fairly significant long conversation with him, didn't you?
Yeah, I was a little ticked off. I thought that was very irresponsible for a concealed pistol license holder to be doing something like that. So I gave him a stern lecture.
Did you run his name?
Yes.
And did you discover he had no prior criminal history whatsoever?
I didn't do a criminal history check. I just ran a check to see if he had a license and if his concealed pistol license was valid.
Okay. And I'm assuming, like most Detroit police officers, you had a body cam on, is that correct?
Yes, I did.
Okay. And I'm assuming you have that to show the court today, that footage?
I don't have footage. My battery died. I indicated in my report that my battery died.
Okay. And your battery didn't die in your police cruiser though, did it?
No,
Do you have the video from the police cruiser that day where my client's in the back?
And I would object, Your Honor, the defense has not requested discovery in writing.
Judge, I'm house counsel. I can't predict that I'm going to get a client. I'm just asking if Sergeant Jackson, obviously there's no offer here today, and I understand his position, right? But I'm just making a point that if this is that serious of a charge, why don't we have dash cam and body cam? That's all I'm asking. I'm just asking him, why don't we have it? I think that's relevant.
He can answer why the body cam and dash cam video is not here. But counsel, he can answer the question that there will be no further assumptions made other than.
I understand where you're getting at, Judge. I get it 100%. I do.
The policy. I just need him to answer the question.
Sure.
That's all he can. Okay, I will allow it.
Thank you, Your Honor.
Do you need me to repeat it, Sergeant?
please do.
You've already answered the body cam question because your battery died. Is there a reason why you didn't present to the prosecutor or the court today the dash cam and the in-car video?
I don't have the dash cam video. I'm not even sure if it's still in the system. It's been well over 90 days. No one requested it from the prosecutors or any defenders, so I don't believe it was ever saved.
Okay, but you'd agree with me that the conversation you had was in the car, your vehicle, correct, with my client?
I had a conversation with him while he was in the car and maybe outside of the car as I let him out.
So you'd agree with me that, I mean, this happened in August. You'd agree with me that the most accurate recitation of the facts or the conversation you guys had would have been on that audio video, correct?
Yes.
Okay. I have nothing further, Judge.
Okay, thank you.
Actually, you know what, Judge? I'm sorry. I do have one question. Sergeant, the defendant was in a public place lawfully, correct? He wasn't trespassing or doing anything like that. He was in the street, correct?
Yes.
Okay. That's all I have, Judge.
Okay, thank you. All right.
And just to redirect, did the defendant explain to you that our altercation was deadly?
No, he did not.
Did he explain to you that altercation, he was in fear of great bodily harm?
No, he did not.
Okay, thank you. Nothing further.
All right.
Nothing based on that, Judge.
Okay, thank you. All right. Does the prosecution?
The prosecution rests, Your Honor.
All
Thank you.
right. All right. Attorney Hill?
Defense calls Mario Petway.
Okay. Is it Mario? I don't want to mispronounce his name.
Yes, you said it right.
There you go. Okay, my apologies for mispronouncing your name, sir. All
You're
right. All right. Remember, you are still under oath, okay?
Yes, ma'am.
All right. Counsel, you shall proceed.
State your name.
Mario Petway.
Mr. Petway, were you in the city of Detroit on or about August 16, 2020?
Yes, sir.
You understand why you're here today, correct?
Yes, sir.
You've heard the sergeant's testimony, correct?
Yes, I heard him.
Why were you down there on that date?
I was down there because my family had an event. And once we left the cookout, me and my lady friend, her two daughters, and my daughter, we was taking a little ride, and the little girls had to use the bathroom. So
Let me stop you there. So you're at a family function, and some minors need to use the bathroom. Is that what I heard? Okay.
Yeah, that's the function. We driving downtown, having a little ride, because we all just left the family function, and then the girls pop up. I have to use the bathroom.
Okay, Mr. Petway, I want you to slow down a little bit because there's a court reporter that has to take down everything you're saying. Okay.
Yes, sir.
Okay. So you stop for the restroom, and the minors use the restroom. What happens next?
Okay, they never made it to the restroom because as soon as they get to the door of the restroom, as soon as they get to the door, a riot break out, fight. Bottles get thrown over their heads. Everybody get to running. That's where the 50 people probably came in most. Everybody running. My daughter them ran away from me. I panicked and grabbed them. At this point, my gun is not out. I'm grabbing them.
Let me
And if
stop
I
you for a second. Again, you have to, do you have a court reporter? Yes,
I can't have a narrative, and I have to be able to follow what he's saying.
I understand, Judge. You have to allow me to ask questions, okay, Mario?
Okay, I'm sorry. First time
Okay.
through this.
I know. And you have to speak a little bit slower so the court reporter can get everything, okay?
Yes, sir.
Okay, so if I understand you correctly, is you didn't get to the washroom yet or the bathroom because there was a riot or a fight broke out, correct? Yes or no?
Yes, sir.
Okay, and your testimony is when that fight breaks out, then you shield the children behind you, is that correct?
Yeah, as the fight broke out, they kind of got, I say probably about a good, well, let me break it down like this. The bathroom door, when I walk up to the door, because it's the lady restroom, I tell them
Let me stop you there. What establishment are we talking about?
before the gun got British. I'm telling you
What business did you visit to use the restroom?
Buffalo Wild Wings.
Buffalo Wild Wings. Okay, do you enter the building, yes or no?
No, they never entered the building because a fight broke out right at the door.
Okay, fight breaks out, you're shielding the children, what happens next?
I think it's, I object, sorry. It's leading that he was shielding the children. I just need to know the conduct and for the defendant to explain that to us.
Sure,
Yeah.
go ahead.
Attorney, wait, hold on. Response to the objection.
That would be leading, I'm sorry, Your Honor, if I didn't say that.
I thought he said that he put them behind him, but I'll read.
Well, at the moment, they was at the door already. So when a riot break out, they run, they get scared. They go where my vehicle at. I tell him around the corner. And he say, well, I'm going to take you around the corner. And I ask him, because I'm scared at this moment, like, you can take me, you cannot take me.
Mr. Petway, anytime someone objects, I need you to stop talking so I can make a decision on the objection, okay?
Okay.
All right, thank you, sir. Okay, can you please state your objection for the record?
It's outside of the scope. It's going into other matters besides what counsel asked Mr. Petway.
Okay, Attorney Hill?
I apologize, I don't understand that objection. I'm on direct examination, of my client.
Counsel, can you repeat your question?
I don't even know what it was now. I think what I asked was basically I just said what happened after the officer ordered him. I think he was just explaining, I said, where were your, I know what it was. I said, where were your children? And he was explaining that a cousin came and took them. Is that right, Mr. Petway?
Yes, sir.
Okay, let's leave it at that.
Thereafter, he began to tell us the story about his interaction with Sergeant Jackson, not the location of the children.
Okay, well, I'm going to get into the interaction with the officer. So if you're going to object, you place it now, I guess.
Well, Attorney Hill, just as you made an objection when she was putting on her proofs for the same reason, and I affirmed the objection, I'm going to affirm the objection for the same reason. Even if you're going to get into the actual interaction with Sergeant Jackson, I'm going to ask that you do a question and receive an answer.
Sure.
I do not hear it from Mr. Petway. So the court is going to affirm the objection, and the court would like you to ask another question to
Sure.
the testimony that you're seeking. Thank you.
Sure. So, Mr. Petway, I understand your cousin then takes the children. You are in the back of a police car, correct?
Yes, sir.
Okay. Did you tell Mr. Sergeant Jackson at that point why you took your gun out?
Yes.
Okay.
So,
Did you tell him the exact same story you're telling the court today?
yes, I actually said,
Sir, yes or no?
not in the exact words.
Okay. What exactly did you tell Sergeant Jackson?
I'm protecting my little girls. They're my girls, and I'm protecting them, sir. I said, I'm just trying to protect my kid. That's exactly what I said. I'm just trying to protect my kid. But he was so upset at me at that moment. It's like, I couldn't really tell him. Then another officer walked up and told him, like, well, this guy got ill. We ain't gonna get on that because you didn't ask me that. So the question is, I did tell him. I explained to him that I was protecting my little girls.
Okay. And you indicated another officer came up and said what to Sergeant Jackson?
Basically, they just let him know, like, oh, he's good. He's a CPL holder. And
Okay.
at that moment, let them know, I don't care. I'm taking this gun.
Okay. All right. And so you indicated the officer was very upset and angry with you?
Yes, very upset and angry.
Okay. Did he ever respond when you told him that you were protecting your children? Did he ever say, Did he ever inquire about anything as it relates to the defense of them?
No, it's like, be honest, if I could tell the truth, I feel like he didn't care because him taking me away from my daughter, I asked him not to because I don't know. I know my cousin, but I don't. I said, you can't take me away from my kids with this all the promotion. And he still took me. So at that point, when I got back to my car, I try to ask officer questions about, because he said, if you want your gun back, call this number tomorrow. And I'm trying to ask questions like, can you write the number down? Can you do this? He pulled off on me. He said, I don't have time.
Let me stop you there. Let me stop you. So he issued you a citation and then let you go?
Yes, no ticket or none of that. I asked, can I get a ticket at that point? He said, I don't have time. I have to get back around the corner. In my eye, I had to run back.
Stop 1 second. So he doesn't even give you a citation. He lets you go?
Yes, I didn't get anything. They brought it out the next 2 days. Somebody came out and served the ticket.
Okay. All right. Did you feel when you unholstered your weapon, did you feel that you were going to prevent harm potentially?
Your Honor, well, no, I will withdraw.
You can proceed, Attorney Hill. She retracted her objection.
Did you draw your weapon to prevent future harm potentially to your children?
Yes, to protect. Yes, sir.
Okay. Did you have any intentions on firing the gun?
Not at all. Ever shot? Not at all. Not at all.
And I believe you've already stated this. You were on a public, you were on the sidewalk or a public roadway, correct?
Yes, sir.
All right. I have nothing further, Judge.
Okay, thank you.
And one moment, Your Honor.
Okay.
Mr. Petway, this is Tamika Horn with the City of Detroit.
Yes.
And you stated that you were in Buffalo Wild Wings, correct?
Yeah, we wasn't inside there. We was outside by the restaurant. The restaurant that's by Buffalo Wild Wings.
So you were not in the establishment ever?
No, we was never inside the building. We was outside.
Thank you. And you heard gunshots coming from inside?
No, not inside, outside.
Did you see the person who you heard the gunshots from?
Not at all. I ain't see the person. I just heard a shot.
So you pulled out your gun
Yes.
after you heard gunshots.
Yes.
Were gunshots near?
They sounded close by. That's why I did. At that moment, I didn't know. That's why I was looking like these. As he pulled up, that's why my body doing this, because I didn't know where it was coming from, but I know it was close.
Were they coming at you?
That I don't know either. My main thing was trying to protect my little girls. I was scared for their life, my life. I don't know.
Were they coming at the children?
Yes, I never had a conversation with anybody.
Were the gunshots coming at the children, to your knowledge?
I don't think so.
And so you willfully and knowingly pulled out your gun without it being an imminent threat to you.
Judge, that calls for a legal conclusion. Don't answer that question. I object. That's for you to determine, Judge.
Court will affirm the objection. Please rephrase your question.
I will rephrase. Why didn't you retreat?
I'm sorry, say that again.
Why didn't you just run away?
That at that moment I didn't think. I'm sorry, I didn't think. I was just thinking about my little girl. Everything else, and I was walking fast away, but I had my weapon out as I was doing it. I didn't run away, but I was walking fast away. I was.
Oh, but you already had your.
Yes, that's basically in my eye. That's basically why I had my gun out, because I'm walking fast back towards our car. So in my eyes, I got this out for our protection.
But it's clear that you pulled out the gun and then you began to run away or walk away.
Yes, as I'm guarding my little girls and looking around, trying to see what's going on.
And You stated that you were served notice of this ticket by mail, correct?
Yes. Because at that
And
point,
when you read the ticket, was it clear to you that this ticket arose from this incident?
yes, I knew the tickets came from.
Judge, hang on, I'm gonna object to relevancy.
Okay, can you explain further your objection, counsel, as it relates to relevancy?
I'm asking that question because early on, counsel asked defendant, Mr. Petway, in quite detail as to how he received the ticket because he was not issued the ticket at the time of the incident. I'm just establishing that the defendant was served with notice and he has received due process under the law of what he was being ticketed for. And so that's the relevancy.
I'll stipulate that there was a ticket mailed to him. I don't stipulate that he was given due process under the law because you can't mail misdemeanor tickets in. But I'll stipulate that he received it in the mail, which is a violation.
You will stipulate that he received it in the mail, but you will not stipulate to the fact that he processed it. So I want to make sure I understand your objection as it relates to relevancy. Can you explain that specifically to the court? As to specifically why you think the questioning and the evidence provided by testimony is not relevant?
It's probably, I probably should have said, it calls for a legal conclusion then, Judge. If Madam Prosecutor is trying to get out the fact that he wasn't served, we stipulated that he was given a ticket, but I'm not going to stipulate that it was proper service because it's not.
Okay, so the objection, you're changing your objection now to objection because of a legal conclusion. Is that correct?
Correct.
Address due process with Mr. Petway, and the court will affirm that objection. If the objection was for relevance, the court will object to that, will overrule that objection. So as it relates to whether you're trying to create a legal conclusion, objection for legal conclusion, the court will
Does not identify who that officer is either.
okay. Saying that someone else told him under hearsay, Michigan Rule of Evidence for hearsay is defined as a statement. The statement was made by someone other than who is testifying today, and for what purpose is this statement being offered, Attorney Hill?
It's not being offered for the truth of the matter asserted, that's for sure. So, I mean, it doesn't even fall within the purview of hearsay. It's being offered, to assert the fact that there was gunshots downtown. It has nothing to do with a statement as it relates to the underlying charges. If my client brandished a weapon, my client's already admitted that he took a gun out.
All right,
And the people would just like to respond. I'm objecting because in cross-examination by counsel of Sergeant Jackson, he asked whether downtown had shots, and Sergeant Jackson said he was not aware of that. So it is almost challenging the testimony of the people's witness.
and you're saying that this is an exception under the present sense impression. Is that correct, counsel?
That falls, yeah, definitely falls within present sense impression, Your Honor. My client calls, he's upset, he's agitated, he calls and he gets a response from an officer on the phone saying there's a bunch of gunshots downtown. And that's the reason why, Judge, it clearly plays into the narrative why Sergeant Jackson didn't give my client a ticket. I mean, I work downtown. Everyone knows that, on the weekends it can get quite chaotic.
Okay, counsel, I'm just trying to understand what I just wanted to make sure that I understand. So for purposes of my ruling on this objection, the objection, and just so I'm clear, is hearsay from Madam Prosecutor. You're saying that this is an exception to hearsay because of present sense impression. And present sense impression requires three things to be satisfied. The statement must provide an explanation or description of the perceived event. The declarant, which in this case is the declarant would be
The officer.
some other officer must personally perceive the event, and the explanation or description must be substantially contemporaneous with the event. Attorney Hill?
Yes, Judge.
Feel like
Yeah,
you
no.
have met?
Yeah, that's my understanding of present sense impression. I don't
Yes,
have
that
it.
is- I'm reading it. I'm reading the law to you, and I want to know, do you think that you have met all three factors for present sense impression exception to the hearsay?
I do, Judge.
I just want to add, Your Honor, the call was made the next day. In addition to what the defendant is testifying to, it's almost double hearsay.
I'm sorry, counsel, I have a question. As it relates to prong two, the defendant must personally perceive the event. When he said he spoke to an officer over the phone, that officer was at the event, or was that an officer saying to him that Sergeant Jackson could not write you the ticket at that time because there are shots being shot in the areas when he's saying that was told to him, but was that officer actually there?
No, I think what the testimony was that he called, right, inquiring as to retrieving his handgun. And I think he was told by whoever he spoke to that there was gunshots downtown. The officer wasn't present there, obviously. There was gunshots downtown, and here's the reason why Sergeant Jackson didn't stick around. That was my understanding.
Okay. That's what I thought. So the court is going to overrule the objection. I'm sorry. The court does not find that all three prongs of this present sense impression exception to the hearsay rule has been met.
So then, Judge, you're just striking his portion of the testimony, because I think Tamika meant to say she's asking the court to strike that portion because it's hearsay. You're just striking that portion.
The court is going to strike that portion of the testimony.
Thank you, Judge.
Okay.
And Your Honor, the people have nothing further of Mr. Petley.
Okay,
Thank you, Your Honor.
you're welcome. All right. Attorney Hill, do you want?
I guess I'd just like to follow up with a couple questions as it relates to this phone call. Mr. Petway, and if you don't know, just say you don't know. Did you get the individual or the officer's name you spoke to the next day?
And you know what? I'm trying to think about it so bad because he actually gave me his number, and we talked it a couple of times. But me calling down there, like Officer Jackson told me, call down there that morning. He never gave me no number, so I played the phone game. I really don't know. I talked to a couple people.
Okay. All right. So the answer is no. You don't know specifically who it was, do you?
I don't, and I had his number at the time. I'm thinking of his name, tip of my tongue, but I can't even tell you.
I appreciate your honesty. No further questions, Judge.
Okay, thank you. All right. Counsel?
Are we moving towards?
Judge, I'm sorry. We rest, by the way.
Okay, thank you.
Sorry, I'm getting Coleman's yelling at me. People are yelling at my office. Sorry.
Needed to know whether you rest. And Madam Prosecutor, you rest as well. Do you?
That's correct, Your Honor.
All right, okay. All right, so at this time, are there any closing statements?
Yes, there are from people.
Yes, as well. Go ahead, Tamika.
Oh, thank you. Your Honor, the testimony that was given by both witnesses in this matter, Sergeant Jackson, as well as the defendant, Mr. Petway, hits to all factors of brandishing a firearm in public, which is a misdemeanor. Number one is defendant's testimony that he willfully and knowingly pulled out a gun. At that time, he also mentioned he was not thinking. At that time, he was not a peace officer. He testified to that, and he was not under duty as a police officer or peace officer. He was not acting in self-defense. He admitted that he didn't believe his children. At some point, he said he thought they were in danger, and then at some point during my cross-examination, he said he didn't believe they were in danger. He pulled out the gun before he retreated. Under the Michigan Self-Defense Act, it specifically says there's no duty to retreat if you feel reasonably that you are subject to deadly force, imminent death or imminent great bodily harm to yourself or others. He clearly explained and stated that he was not thinking. He didn't begin to retreat until he pulled out the weapon, a weapon that could kill someone. He's not sure how many shots he heard. He wasn't sure if it was one or two. It was close by, but he also admitted that he didn't believe he was being shot at, nor his children were being shot at. He just simply didn't know. I believe the people have proved beyond a reasonable doubt, based on Sergeant Jackson's testimony as well as defendant's own testimony, that he illegally brandished a weapon in a public place. And it is the people's position that that creates a danger to our citizens, a deadly danger to our citizens. Thank you, Your Honor.
Thank you. Attorney Hill?
May I, Judge?
Yes.
Luckily for my client, there is an exception to the brandishing firearm statute, Your Honor. A person lawfully acting in self-defense or defense of others under the Self-Defense Act. Now, I'm not saying that the officer is not telling the truth. I think he is. I think he's credible. So is my client. What I will say is this, is that my client's been living with this every single day since this incident happened. I know a lot of officers, right? I've seen Sergeant Jackson downtown. My office is downtown. There's probably 100 interactions he's had since this day, right? And again, I'm not saying that he's not telling the truth. What I'm saying is that my client's testimony is just as credible as Sergeant Jackson's. And as it relates to the truthfulness, again, I think you can hear in my client's voice, just his demeanor, he's telling the truth. And the one thing I appreciate so much is he said he didn't think. And I know the city's trying to use that as a dagger to my client's self-defense argument. I'm a father, and I don't know, I can't tell you, if I heard gunshots and I had my two twin girls behind me, I don't know what the heck I would do. And, you know, I'm Canadian, so I can't have a CPL, but I don't know what I would do. And I think what he did is completely reasonable. He sees a bunch of people running because there's gunshots. He pulls out his gun. He doesn't start shooting at things. He's just fanning to make sure that there's no shooter around. I disagree with Ms. Horn's statement about him at some point saying his kids weren't in danger. He never said that. I asked him very specifically, were you in fear for your life or did you feel threatened? He said, yes. And then he said, I felt more so for my children, my kids behind me, right? What I think we have here, Judge, is and it all plays out to even the factual scenario that Sergeant Jackson said, right? There's a fight, somebody pulls out a gun, there's a gunshot, people start running. That individual that talked to Sergeant Jackson could have been talking about the actual shooter, but we don't know because there was never any follow-up. It's clear from the brandishing statute, and my client's been brutally honest with the court, he did take the gun out. But fortunately for him, there's an exception. An exception is that if he feels threatened or if he's defending other people. And I think clearly, Judge, he said he walked away very quickly with the gun to get his children and himself out of harm's way, more specifically the children. The law on this, it's common law self-defense, Judge, right? And as long as, if you look at the, there's a lot of case law on this that I did a very, very brief research on. The only time self-defense doesn't work is if my client's the aggressor. right? If he's the one that's actually starting the original crime. That's not what happened in the situation. There's somebody else that fired a gun. So right there, he meets that pro. Was the defendant legally on the premises? He's in the public place. Sergeant Jackson already testified. He wasn't trespassing. And thirdly, did the defendant engage in lawful conduct at the time of the incident? That's the self-defense argument, Judge. I wouldn't be making these arguments if he was firing the gun to credit people. I think what he did was completely reasonable under the circumstances, as stated by the officer and by Mr. Petway. Fight, there's chaos, there's gunshots. I would do the same thing. I would do exactly the same thing in that factual scenario. Judge, you're going to read the law and you're going to apply the facts. The only thing I will say is this. This is something I learned from Judge Giles a long time ago when I first started practicing. I think both the officer and Mr. Petway are credible. And when you have two people that are credible, the burden is so high in a prosecution of a misdemeanor, beyond a reasonable doubt, it's a tie, right? And I'll never forget my very first trial with Judge Giles. He said, you know what? I believe both parties. And the tie goes to the defendant. It's that high of a burden, Judge. And I don't think my client has done anything to suggest he's not credible, especially because he's been living with this every single day since August 16, 2020. So I would say that the prosecution has not even come close to meeting their burden based on my client's testimony. And I ask the court to dismiss the charges.
Thank you, counsel.
Okay.
Your Honor, just one response, and I'll make it quick and short, I understand.
No,
In counsel's own words, defendant was fanning a gun, a firearm. Fanning is brandishing. He didn't see the shooter, and notably pulled out the gun, as he stated, prior to retreating. There was no direct threat, no imminent threat of great bodily harm or death. The people believe that in that position, when he was not thinking and brandishing a gun, that Mr. Petway was the actual threat. There were many people running around, at least 50 people. Anything could have happened while he was not thinking. There's no direct threat, and there's no tie here. Thank you, Your Honor.
All right, the court's just gonna take a brief recess. Court's gonna take a brief recess just to give me an opportunity to review all the facts and do my analysis, okay?
Thanks, Judge.
All right, you're welcome. Thank you.
Thank you very much.
All right, thank you, all counsel. And thank you, Mr. Petway and Sergeant Jackson.
Yes, thank you, Sergeant Jackson.
Thank you.
Thank you, Sergeant Jackson. Thank you.
All right, I am
Thank you.
going to take a brief recess. I am going to place you in a waiting room and I'll bring you in when I'm ready for my decision, okay?
Sounds good.
All right, thank you.
Thank you.
Thank you.